the screen. This is Democracy Now!, democracynow.org, The War and Peace Report. We're broadcasting from San Francisco on our many-city Community Voices Community Media Tour. Right now, we're talking to Scott Horton, the human rights attorney and blogger. We're talking about the latest news on President Obama releasing 4 lightly redacted memos from the Bush-era Justice Department, but saying that that CIA officials need not fear prosecution. I wanted to go for a minute to what former CIA Director Michael Hayden had to say on MSNBC Thursday. This is before the release of the memos.
On balance, the agency's view, certainly my view, is that on balance, the release of the memos harms American security, and therefore I think the best course of action would have been to have kept them classified. The President, when he issued his executive order tying all American agencies to the Army Field Manual, also launched a 6-month study to determine whether or not the Army Field Manual and the techniques, the 19 techniques contained therein, are sufficient in all cases facing the Republic. The degree to which we make these techniques public, that we tell our enemies the outer limits of American interrogation techniques, it moots the study that the President directed, because it will effectively take these techniques off the table, because our enemy will know all of our approaches to him. So there are a variety of reasons I think it would have been best to keep the technique secret. That's just one of them.
Scott Horton, your response.
Well, I think if we had a little bit more candid Michael Hayden, we'd hear him saying something else. In fact, it was reported in Bart Gellman's book, Angler, that around the time of the 2004 elections, he had a very, very strong focus on and fear of prosecution if the things he was involved with should become public, a matter of public knowledge. And I think that's what's in the back of his mind here. I don't think it's national security at all. In fact, these techniques are very well known. The Red Cross report, which was published, you had Mark Danner on your show talking about it, described all these techniques in terrific detail. I mean, so it was, in a sense, no surprise when we saw these memos. They were describing the techniques we knew and we anticipated based on the Red Cross's own report. So no surprise, no news, and concern by General Hayden for his own hide.
We just got this report from Spain's Scott Horton. Spanish prosecutors have formally recommended against an investigation into allegations that 6 senior Bush administration officials gave legal cover for the torture of terror suspects at Guantanamo Bay. While their ruling is not binding, the announcement all but dooms prospects for the case against the men going forward. That a report from the Associated Press. Scott Horton, can you explain what you understand at this point?
Well, the Associated Press is giving you extremely faulty legal analysis because a decision as to whether the case will go forward rests entirely with the investigating judge. The Spanish system is not like the American system, where prosecutors decide who and when to bring cases and who to prosecute. In the Spanish system, the prosecution is managed by an investigating judge. In this case, it's Baltasar Garzón. And you may recall he handled the case involving Augusto Pinochet, and he did that against the stern opposition of Spanish prosecutors, I think, which shows you the weight that recommendation may hold with him and his court. But there's a different consideration to weigh in here as well, and that is that this is a statement that was announced by the prosecutors at the Audiencia Nacional in Madrid. And we know, in fact, that those prosecutors who made this recommendation not to go forward, in fact, concluded that the case should be prosecuted. They prepared a 37-page memorandum, and I've talked with several people in Madrid who've read it, that laid out the case, showed how it could fairly easily be brought, how it involved a joint criminal enterprise, how it could be sustained on the basis of documents, including some of those that were released yesterday. And that decision by the career prosecutors was overridden in a political act by Spain's Attorney General, who's a political figure, who is a member of the cabinet of Prime Minister José Zapatero. Moreover, the Attorney General's decision, which was announced yesterday morning in Madrid, came after several days of high-level discussions between Washington and the Zapatero government, during the course of which I've been told the Obama administration suggested very strongly that the pendency of this case was inconvenient, and that it would be viewed as a great favor by Washington if Zapatero's government could do what was within its power to shut this down. And I think what we see here is an accommodating nod from Jose Zapatero. So it has really nothing to do with justice, and it has nothing to do with the merits of the case. It's a political act, and it's certain to be understood by the judges of the Audiencia Nacional as a political act, which means I don't think it really forms much of a barrier to the prosecution going forward.
Scott Horton, I want to thank you for being with us, a blogger and lawyer who's been following these cases very closely, speaking to us from Washington, D.C. As we turn right now to an issue of prisons here at home. While President Obama's pledge to close Guantanamo and the secret overseas CIA prisons, calls are increasing for him to re-examine the treatment of prisoners detained as part of the so-called war on terror being held inside the United States. With little public scrutiny, the Bush administration opened 2 secretive prisons in Indiana and Illinois, known as Communication Management Units, or CMUs, that are designed to severely restrict prisoner communication with family members, the media, and the outside world. Dozens of Muslim men are still being held at the CMUs, as well as other prisoners, including environmental and animal rights activists. The government's provided little information about the special prison units. A search on the Bureau of Prisons website yields just 1 document, even mentioning the program. Only a handful of news articles have covered what's been described as a little Guantanamo by some of the prisoners. The first CMU was opened in 2006 in a special isolated wing of the federal prison in Terre Haute, Indiana. A second CMU was opened last year in Marion, Illinois. Prisoners held inside the special unit include Dr. Rafil Dafir, the Iraqi-born doctor from upstate New York who's serving a 22-year sentence for violating the Iraqi sanctions by sending aid to Iraq through his charity Help the Needy. Yassin Aref, the Kurdish-born imam from Albany, New York, who was convicted in a controversial FBI sting operation. And also the environmental activist Daniel McGowan. He's serving a 7-year sentence for his role in 2 acts of arson. Some critics have suggested McGowan and other non-Muslim prisoners are being held in the CMU because the federal government wants to avoid accusations that the CMUs are designed to only hold Muslim men. The Bureau of Prisons declined our invitation to join us today, but in a written statement, a Bureau of Prisons spokesperson said, quote, "Race and religion play no factor in an offender's designation to this unit. It's solely based on their need for increased monitoring of their communications." We're joined now in Washington, D.C. by Will Potter. He's a freelance reporter, editor of the website greenisthenewred.com. Earlier this week, he published an article called Secretive U.S. Prison Units Used to House Muslim, Animal Rights, and Environmental Activists. We are also joined by 2 attorneys who represent men being held in these cases. But Will Potter, just lay out the story for us.
Good morning, Amy. Thanks for having me. These CMUs are so-called self-contained units in 2 facilities in the country. There's one in Terre Haute, Indiana, and another in President Obama's home state of Illinois at Marion. And according to the Justice Department and the Bureau of Prisons, they're being used for inmates that need increased communications monitoring. In practice, what we're seeing is a roundup of inmates from a variety of prisons across the country that are being put in these CMUs and having intense communications monitoring take place that rivals some of the most extreme prisons in the country, including ADX, the Supermax in Colorado. And these inmates were taken there. They're given no opportunity to appeal or have a hearing of their designation. Once they're there, they have extreme restrictions, including having all phone calls monitored and limited to 15 minutes a week, where the average is about 300 minutes a month. You have visitation restrictions that are including no personal contact and limited to 4 hours a month, whereas with the ADX Supermax, for instance, visitation hours are 30 hours a month. And on top of that, you have a restriction of due process rights. These individuals have no idea why they're there, and they have no means of challenging it.
How much is known about these prisons? How much has been written about them?
Not very much has been written about it, and very little is known. I have a Freedom of Information Act request obtained through attorneys that requested to know who actually is in these facilities. The government acknowledges that they exist. The government acknowledges that, through their institutional supplements, what the policies are, at least the skeleton of those policies. But the government refuses to say who is actually there, why they are there, and how they can get out if they want to appeal that designation.